Welcome everyone to today's webinar on New York State Paid Sick Leave Law presented by Barclay Damon. Many thanks to our presenter Michael Schiotti for being with us today and all the participants who have joined in. Please note this webinar is being recorded to share what we learn with the business community. Michael will share his presentation with you, then follow with ample time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Mike to start things off.
Great, thank you. Good morning, everyone, and welcome to today's presentation on the New York State Paid Sick Leave Law. We have a fair amount to cover in a relatively short period of time. The one thing I want you all to realize right out of the box, we are still waiting for guidance from the state of New York. So what we're going over is the statute and the statute only. The guidance has not been published yet. It was supposed to be published prior to today. Welcome to the great state of New York. They're probably going to publish it maybe Friday or next week or God only knows when, but we don't have that guidance yet. When we do have the guidance, we'll probably have to have another webinar to go over because the guidance is going to fill in the gaps. I'm already getting questions from you. I had one set of questions yesterday about how to count employees, which I will answer when we get to that. And I had a question this morning on front loading and the impact of front loading, and I'll answer that question as well in this presentation. But if you sort of feel like the statute itself has holes, you are totally correct. There are commentators out there, people writing articles saying this is the answer, this is the answer. Wait to the guidance. They may be right, they may be wrong. I'm taking some educated guesses on what the state of New York is going to do to fill in the gap. We'll see in that regard. So, one of the questions is, the COVID sick leave law does not expire at the end of the year like the federal Family First Coronavirus Response Act. Does that mean, does that leave get rolled into the sick leave, or is it in addition to the sick leave? What if you have something that qualifies as paid family leave and sick leave? Who gets to choose? Does it run concurrent? We don't have those answers yet because the state of New York has not published the guidance and what have you. So again, we know what we know. It's going to be enough to get you started going down this path. Some of you realize there is a September 30th today. If you're going to use the accrual method, you have to start the accruals today and what have you. I'd still wait for the guidance. If the guidance is 2 weeks out, make an informed decision. Are we going to front load the paid sick leave or use the accrual method once you have the guidance? And then just simply, if you do the accrual, just say when you publish your written policy, we're doing it retroactive to September 30th, and that is the date we're starting the accruals. So there's a lot of moving parts here. We don't have all the answers, but we'll give you the answers that we do have right now. Again, just please remember this is a presentation. It's not legal advice. If you really need us to get nasty with you and go into your policy and look at your policy and review your policy, we're happy to do that for you, but we're trying to simply give you a general overview here today. Here's my contact information. I am also on Twitter and LinkedIn. If you send me a LinkedIn request, I will let you into the group, and you're free to follow me on Twitter. I post lots on labor and employment, and I post lots on other legal topics as well. It's a good way to stay informed. So what's our agenda today? Again, a lot. There's a lot in this little law. We're going to go through some general information about the law. We'll tell you who's a covered employee and who's a covered employer. We'll talk about the benefit requirements because the benefit requirements are not the same across the board. You're going to see that it depends on the number of employees you have, as well as in at least one case, your net income from the prior tax year. We're going to talk about the funding options, which I've already alluded to. You can either front load all the sick leave on 1/1/2021, or you can use the accrual method, and the accruals would start today, September 30th, 2020, but you don't have to allow them to take the sick time until 1/1/2021. So there are good reasons to do the front load. It's simple. There's bad reasons to do the front load. You can't take it back. Once you give it to them, you cannot take it back from them. There's a good reason to do the accrual. They have to work to earn it. There's a bad reason to do the accrual. You got to track it, and it's more difficult to track, and it's a pay period by pay period issue. We're going to talk about the employee's use of sick leave. It is not just for the employee's sickness. You need to realize that. The other thing that's going to come into play here, we recently had a webinar which we put on for the Chamber on the domestic violence protections that New York State has enacted. And those of you that participated in that webinar, which I spoke at, realized that it was unpaid leave. Now, with the New York State paid sick leave law, the domestic violence leave becomes paid leave because they've rolled it into the sick leave. So we'll explain the use of that. It's also not just for the employee's sickness, it's a family member. They define a family member, they define a parent, they define a child, and you're going to see it's a very broad definitions in that regard. Another section I had, I called it employer limitations. They're really rules that apply to the employer, which we'll go through for you. There are carryover rules. You have to allow carryover. In some of you out there, some of your sick policies allow it, some don't. But you're going to have to allow it here. It doesn't matter which method you use, whether it's front load or the accrual method, but depending on your size, you're going to be able to cap the use of an employee's sick time at a certain number of hours, and we will go through that as well. What is a good employment law without a non-discrimination provision and penalties associated with it in that regard? We'll go through that as well. I've already had a question pop up in the chat about PTO. Can we continue to have our PTO policy, or do we need to segregate out the sick leave? That's up to you. We're recommending that you segregate out the sick leave for tracking purposes. You are free to use your existing PTO plan in that regard. There are some unanswered questions. You know, let's say, for instance, the employees have 100 hours of PTO that's available to them, and they take 99 of it and they use it for vacation and only 1 hour for sick leave. Does that mean the employee gets to carry over any sick leave in that regard? I don't think so, but I don't know the answer for sure, and that's why we have to wait for the guidance. So we'll go through the existing employer policy rules and what have you. We'll talk about the impact of a collective bargaining agreement, and you're going to see the rules are also only deals with those collective bargaining agreements that come into play on or after the effective date. So what about existing collective bargaining agreements? Well, this is a law. Some of your collective bargaining agreements have a clause that says we have to follow the law. So if something comes into play afterwards, we have to do this in that regard. So we'll talk about the collective bargaining agreements. I'll give you some ideas existing. You're probably going to have to ask the union to open it up. And if they refuse to open it up, maybe file a charge against the union. There is a job restoration rule, very simple. We will go over that with you. There's an employee usage rule. What that is the employee is going to be able to ask you as an employer, how much leave have I used? And you have to tell them, and you have to respond in writing. We're going to talk about the impact of local laws. New York City has a paid sick leave law. Westchester County has a paid sick leave law. New York City, I think Monday of this week enacted sweeping changes to make their law work a little bit better with the state law. So if you're down in New York City, we're not covering that here today. You have a presence down there. You also have to comply with that. If you're in Westchester County, you also have to comply with that law. Lastly, we'll go over the record retention requirements and what those record retention requirements are. And I know that the questions are already coming in the chat. I promise I'll get to them all at the end. Bear with me. My guess is I will answer most of your questions before the end that I know the answer to, and the other things will give some educated guesses. So let's first talk about some general information. Those of you that heard me present before, I don't like legal citations. I have to point something out here. They have added the New York State paid sick leave law as a section 196B into the labor law. That's important because that is Article 6 payment of wages. The Article 6 payment of wages has existing definitions for an employer and an employee, which apply in this case. So we're going to show you those. So they dropped it into an existing law. The accrual rules, as I've already mentioned, start today, September 30th, 2020. Again, don't go crazy thinking you have to have in place today a written policy. I think you have to have in place a written policy by January 1 of 2021. I'd probably publish it sooner. The reason you have to have a written policy, there's an existing provision of Article 6 of the labor law that says you as an employer must inform your employees in writing what your policy is on sick time. It's already in the law. You must have a written policy. So you're going to have to modify it, make an informed decision, do it on or before January 1, 2020. Okay, so next, more to come. As I've alluded to, the Department of Labor within the law was directed to adopt regulations and guidance to basically fill in the gaps. The gaps that they have been directed to fill in, the standards for sick leave accrual, the use of sick leave, the payment of sick leave, and employee eligibility. And they can go into other areas as well. So when we realize, yeah, we know what we know, this is going to be the first of a building block we'll have another webinar that sort of fills in the rest of the information once they choose to tell us what that is going to be. We actually checked first thing this morning just to make sure it didn't sneak in overnight, and we haven't seen it yet. Of course, just with my luck, as soon as we're done with this webinar, they're probably going to publish it and fill in some gaps, but not anything we can control. So let's talk about covered employees and covered employers. The law, as I've explained to you, they put in Article 6 of the labor law. Article 6 of the labor law has an existing definition of what an employee is. It's basically all of your employees. It means any person employed for hire by an employer in any employment. There's no distinction between part-time and full-time. There's no distinction between per diem and others. So we're going to have to, what is the front load rule with a part-time employee? What is the front load rule with a per diem employee? It can't be that they get the full amount. I agree. I don't think it is. And I think it's going to be on some pro rata basis, but we're going to have to wait for the guidance to give you a conclusive answer in that regard. The law also adopts the existing definition of an employer. I'm not going to read it. It's basically everyone on this call. Everyone viewing this webinar is a covered employer, with the exception the employer does not include a governmental agency. So they've excluded themselves from this law. Not surprising, they do that quite a bit. This is an unfunded mandate. You as an employer currently do not have to give your employees any sick time. There's no law in place unless you're in New York City or Westchester County that mandates that you give employees paid sick leave. This now does. It is what I call an unfunded mandate. You have to provide to the employee, depending on how many employees you have, and in at least one situation, your net income from the prior taxable year. And we're going to go through these scenarios with you. And even though I called this New York State paid sick leave law, you're going to see the first category, it's unpaid in that regard. And I underlined and highlighted that just to make sure once we get to it. For purposes of what is the time period I look at for purposes of determining how many employees I have? You use a calendar year method. It's going to be a 12-month period from January 1 through December 31 in that regard. So please remember, this also might be an ongoing scenario. So if suddenly you currently have less than, let's say you got 75 employees, but next year you grow and you're at 150, the rules are going to change. You're going to have to realize that and adopt your policy accordingly. So what is the first bucket that we have to deal with? We have 4 or less employees, again, 4 or less employees, and the employer's net income was less than $1 million in the prior tax year. In that scenario, the employer has to provide up to 40 hours of unpaid sick leave. What does the up to mean? If you're using the accrual method, they have to basically work to earn it. And we're going to explain to you what that accrual formula is shortly. If it's front load, you give it all to them on January 1. And if you do that, you can't take it away from them. So theoretically, what it would mean is this. You have an employee get sick on January 2nd. You have front loaded their sick time. They use all their sick time in the month of January. On February 14th, they quit. Can I get any of it back? No, you can't, because you're front loaded. That's front loading makes tracking easier. You don't have to worry about the accruals, but you can't get it back, and they're allowed to use it. One question I saw pop up, do I have to pay an exiting employee their paid sick leave? You do not. The law says you do not. As an employer, you are free to give away as much money as you wish to your employees. You are free to adopt a policy that says, I'm going to. That's up to you. That's a business decision. It is not a legal decision. So that's bucket number 1. Bucket number 2, not a big change. It's 4 or less employees, and your net income from the prior tax year is greater than $1 million. In that situation, you have to provide up to 40 hours of paid sick leave. So now it turns to paid. If you have between 5 and 99 employees, it is the same rule. It's 40 hours of paid sick leave in each calendar year. And lastly, if you have 100 or more employees, you have to provide up to 56 hours of paid sick leave in each calendar year. So again, those are the various buckets. You have to figure out which bucket you're going to fall into on January 1, and basically adapt your policy. It must be written. It must be distributed to your employees accordingly. Does the net income rule fall off if over 4 employees? Yes, it does. The slides are very specific for a reason. The net income only applies in those first couple we need to look. Once we get above 5 employees, the net income rule disappears in that regard. Good question. Greater benefits. Can I give away more to my employees? I don't like the accrual that the state of New York is making me do, which we'll get to. Can I accrue it at a greater rate? Absolutely, you can. Can I have more and greater benefit policy? Sure. Some of you that have PTO, you may, and if you're going to break out your sick leave, it might result in a reduction of the PTO number. Some employees, one of the things I want you to consider is the impact of the changes on your workforce. And are they going to be grumpy? Are they not going to be grumpy, given what you're doing? I think that's at least something I'd like you to consider. Benefit requirements and funding options. As I've indicated, we have two methods, the front load and the accrual. Each has its own good part and a bad part. The front load, in essence, you give them everything on 1/1/2021. You don't have to worry about this September 30th date in that regard. So question that just popped up, can we front load but control the number of days per month? No. As of right now, the statute is clear. If you front load, you're going to front load it all. And there's not going to be room for what I call a modified version of it, based on, we'll do it on some type of monthly basis. Now, again, let me be very clear. We have to wait for the guidance from the state of New York, because the funding mechanisms, there's hardly anything in the law on them. And I've put everything in here you're about to see on these slides. And you're going to be like, wow, that's not a lot. Yeah, they really didn't give us a lot. So we can front load in that regard. Another question that's come up, where does FEMLA come in? For instance, after 3 days, can we require FEMLA to run concurrently? I think if it's a FEMLA qualifying event, you're going to be able to make FEMLA run concurrently, but you have to remember this is paid leave in that regard. So we're going to have to take a close look at FEMLA to make sure it can run concurrently in that regard, because FEMLA does make a distinction in certain cases where the leave is paid or unpaid. So you just have to basically look at FEMLA in that regard. Then we have the accrual method. The accrual method, in essence, is fairer to the employee, to the employer, because you only have to grant the sick leave that the employee has actually earned based on working. The downside to it is you have to basically track it and what have you. On the front loading, basically an employer may elect to provide its employees with the total amount of sick leave required at the beginning of the calendar year. Provided there's a couple rules that will come into play. You cannot, if you choose to front load, reduce or revoke the leave based on the number of hours actually worked by the employee during the calendar year in that regard. So that's the bad part about it. One of the questions that's popped up, how do we front load for a salaried exempt? How do we front load for per diem, a part-timer? How do we do the accruals for them? I don't know. The part-timer, I think, is easy. It's based right now based on their number of hours of work. So in the first week, if you're using the accrual method, they work 20 hours. The next week, they work 10 hours. They earn one day of sick leave. You're going to see that. I'm going to get to the accrual calculation in a second. The accrual method, you as an employer, this is the minimum accrual that's allowed. You can do more. If you pick the accrual method, employees are going to accrue sick leave at the rate of not less than 1 hour for every 30 hours work. The accruals will start on September 30th, 2020. Do I include overtime hours? Yes, you do. It's an hour worked in that regard. Do I include when they're on leave? No, you don't, because that's not an hour worked. What if they're on FEMLA? Can we count when they're on FEMLA, short-term disability, workers' comp leave? No, those are not hours worked. It is truly tied in to hours worked. You can make the accrual higher if you wish, but you can't go below this. If a part-timer, again, going back to the example I gave a minute ago, works 20 hours one week and 10, the next, you have to track that because this is going to build on each other. So it's not just what did you do in the work week, it's you have to track every 30 hours worked and then give them the paid sick day. I'm hopeful the guidance gives us some more information on front loading and accrual. I really hope they do, because what I just had in this presentation is all the information the state of New York has given us thus far. Some of you will say, can't we look at the New York City law? Well, that's New York City's interpretation. It may be helpful to us if once the state issues the guidance, there's no answer. We may have to make a common sense leap here, but we'll see. I'm hopeful they'll give us more information and guidance. Okay, employees' use of sick leave. This is going to be a radical departure for some of you. Some of you right now only allow an employee to use sick leave for their own sickness. That is no longer the case under the use requirements in the paid sick leave law. Some of you are very lenient, allow it to be used for other things. The domestic violence presentation that I did several months ago comes into play here. If you haven't looked at that, I encourage you to go back and take a look at what the human rights law now requires for victims of domestic violence, because the paid sick leave law builds on that presentation in that regard. So effective January 1, 2021, an employer is going to have to allow an employee to use sick leave for any of the following reasons. I haven't got to you yet what we can ask an employee about sick leave. Not much is going to be my answer. I think it's going to be as simple as them calling in and saying, I'm sick. And there's not going to be much you're going to be able to do about it. It's going to suck for planning purposes, and it's going to make your life difficult if you break out sick time, because an employee may want to not lose that bucket and may suddenly be sick a lot towards the end of the year if they're going to lose the sick leave. And I'll explain why I think some of you may want to allow carryover, even though it's mandated. You're going to see in a second, there's a limitation that you can place on the amount of hours an employee can use for sick time. I'm not sure that's going to be a smart idea, but I want you to think about it, at least from a business perspective. So what can an employee use sick time for under the new law? So I'll go through this. I've highlighted some words just to make it clear. At the end of the use rules, there are definitions for a family member, a parent, and a child. I'm going to go through those. I know that's going to be a question, but I put that later, a little later after these slides here. So I just want to go through the use and make sure you understand them. It's a mental or physical injury, illness, or health condition. Very broad. You're going to see that language repeated throughout the use rules. For such employee or the employee's family member, regardless of whether the injury, illness, or health condition has been diagnosed or requires medical care at the time that such employee requests such leave. You're going to see in a few rules, in a few slides, there's a confidentiality provision. An employee does not have to disclose confidential medical information to you as an employer under the paid sick leave law. So we'll go through that in a second. So that's the first bucket under the sick leave use. The second bucket is for the diagnosis, care, and treatment of mental, physical injury, illness, or health condition, the need for medical diagnosis, or the need for preventative care for the employee or the employee's family member. So that's the second bucket. The third bucket builds on the domestic violence presentation that I did. For an absence from work where the employee or the employee's family member has been a victim of domestic violence pursuant to the section of the Human Rights Law, a family offense, sexual offense, stalking, or human trafficking. There's a caveat in the law, which will be on the next slide. What if the employee was the one that assaulted their child? Can the employee request and receive paid sick leave under the law? No. There's a provision we're going to show you in a second that basically says if the employee is the individual that did committed the act of domestic violence, the family offense, sexual offense, or stalking, they are not entitled to paid sick leave. The domestic violence reasons, very broad. The reasons include to obtain services from a domestic violence shelter, rape crisis center, or other service program, to participate in safety planning, temporarily or permanently relocate or take other actions to increase the safety of an employee or an employee's family, to meet with an attorney or social services provider to obtain information and advice and prepare for, participate in a criminal or civil proceeding. Those have to relate to the domestic violence component, the human trafficking, etc. So if your employee wants to take paid sick leave because he got in a car accident 6 years ago and he's about to go to trial and he needs to meet with his attorney, the answer is no. If the employee is going to family court to get a order of protection against because of their abusive spouse, the answer is yes. So it depends what it is. Paid sick leave can also be used to file a complaint or domestic violence incident for law enforcement, to meet with the district attorney, to enroll your children in a new school. This has been getting, I've been getting pushback on this. The rationale is really simple. Sometimes a victim of domestic violence needs to relocate. When they relocate, they take their children with them and they have to enroll the child in a new school. The key is they had to move because of the domestic violence to get away from the abusive spouse, the abusive boyfriend, whoever it may be, or to take any other actions necessary to ensure the health or safety of the employee or the employee's family member, or to protect those who associate or work with the employee. Very broad buckets in that regard. Again, the reasons outlined in A through G must relate to domestic violence, family offense, sexual offense, stalking, or human trafficking. If your employee simply moved into a new house, for instance, and then has to enroll their child in the new school district, had nothing to do with domestic violence, you don't have to allow them to use paid sick leave. And again, if your employee was the one that committed the sexual offense, the domestic violence, they are not entitled to take paid sick leave. As promised, there was a definition for family member, parent, and child. Family member is defined here. It means not only the employee's child, but their spouse, domestic partner, parent, sibling, grandchild, or grandparent, and the child or parent of the employee's spouse or domestic partner. Very broad. Parent means biological, foster, step, adoptive, or legal guardian, or the in loco parentis concept, which the Obama administration introduced to us under FEMLA. Very simple. In loco parentis is an example is the following. A couple has a child that's a minor. They die in a car accident. In their will, they make the next door neighbor the legal guardian of the child. But let's say they don't adopt them, and they're going to stand in loco parentis. Sometimes you have an aunt that raises the child. They will stand in loco parentis. There is overlap amongst the definitions. So don't assume it has to be a biological parent. Child, again, very broad, biological, adopted, foster, etc. So employer limitations, that's what I called it. I for lack of a better term, maybe these are rules that apply to employers. So some of you are already sensing there's going to be a potential for abuse here. The employee just calls in sick. Yeah, I hate to say that. If you have sick leave now, it's the same. It's the same situation. If I catch an employee doing something they're not supposed to be doing when they claim they were using sick leave, can I discipline for them? Sure, you better be right, is mine. So one time we had an employee caught on a TV camera walking in the mall when he was supposedly out sick. They confronted the employee had a great answer. I was in the mall because that's where my pharmacy was. They needed a half an hour to go fill my prescription. I took a walk, I came back, here's my receipt. That's why I was there. So don't prejudge what you see. Always ask the employee. The slide here indicates in sum and substance, as to the use of paid sick time, you cannot ask for confidential information. So if you have to go meet with your attorney, well, what did you talk to your attorney about? No. Can you give me a note from your attorney saying you met with him? I think that's okay. I had to go meet with my attorney. Who'd you meet with? Johnny. That's fine. I had to go to the doctor's office. That's fine. Who's your doctor? I don't know. What if the doctor is Dr. Jones and he's an oncologist? Is that the disclosure of confidential information? Maybe, because we're disclosing you're seeing a cancer doctor. So I think we're going to have to wait for the guidance here. I hope they give us some examples of what we can ask for and what we cannot ask for. Right now, this is the only thing that I can tell you. You can't require the employee to release confidential information. Can I, as an employer, let's say the employee is going to use sick leave, what is the increment I have to allow them to use it in? So an employer may set a reasonable minimum increment for the use of sick leave, which shall not exceed 4 hours. So what if the employee only needs 2 and comes back to work after the 2? I think you're going to have to put him back on and let him work. I don't know. I stand to be corrected by the guidance. I don't think you're going to be able to force the employee to take more leave than they are required to. So we'll have to wait for the guidance in that regard to see if I'm right or wrong. When do I have to pay the sick leave? So the employee will receive compensation at their regular rate of pay. Now that is a term of art. What is the regular rate of pay? Or the applicable minimum wage, whichever is greater. If you're not paying your employee minimum wage, I'd like to know why, for the use of paid sick leave in that regard. So that's the pay requirement. I think it's that's all we know as of right now. If the employee's employment ends, do I have to pay the unused sick leave? The answer is no. Can I? Sure. Can I have a modified approach to it? Meaning I'll pay it out if the employee gives me notice and works their notice period. I'll pay it out unless the employee was terminated because they were stealing from me. You can create those other rules if you wish. Those are business decisions. You do have a little flexibility in that regard. The carryover rules. Okay, we're going to have to allow carryover now. Some of you already do, no big deal. Some of you do not, and you're going to have to get used to allowing it. So an employee's unused sick leave will be carried over to the following calendar year, provided that an employer with fewer than 100 employees may limit the use of sick leave to 40 hours per calendar year. And if you have 100 or more, you may limit the use to 56 hours per year. Some of you may say, well, why allow the carryover at all? Well, what if you're using the accrual method? So they earn, let's say, 56 hours in year one, and they do not and they do not use any. You carry over all 56. They have the 56 available. You also put in place a rule that says you can't use more than 56 in a year. Well, that makes total sense because the accruals begin again on January 1 in that regard. So the front loading, we'll see what they do in that regard. I see no distinction. If you front load, you have to still allow carryover. It just means they have a lot more leave available to them on 1/1 of the following year. But you still can put that cap in there if you wish. That is up to you. So some of you want to do the calculation or the front loading based on some other date, maybe the employee's anniversary date. Yes, you can. A calendar year for purposes in this section means January 1 through 12/31, or a regular and consecutive 12-month period as determined by the employer. I think the state is going to flush this out a little bit more to give us some more guidance, so we'll see how it goes. Again, what is a good employment law without the ability of the employee to sue you? They have the ability. There are non-discrimination provisions. You can't, excuse me, discharge, threaten, penalize, or in any manner discriminate or retaliate against any employee, or because such employee has exercised his or her rights under the law. Exercise the rights mean requesting sick leave consistent with the law, using sick leave consistent with the law. The law has adopted the existing penalty provisions in the labor law, which are located at Section 215. These have been around for years. Section 215 permits an employee to bring a civil action or file a complaint with the New York State Department of Labor. The New York State Department of Labor has set up an anti-retaliation unit. They're down in New York City. Their sole purpose is to prosecute claims brought against employers for retaliating under various labor law provisions, and this would be one of them. And I can assure you, they don't move fast. I have one case that's been pending now for 3 years with that group, and I see no end in sight, unfortunately. The penalties that are associated with Section 215 of the labor law, you could be penalized if you violate the non-discrimination provisions, up to $10,000 for the first offense, up to $20,000 for the second offense. You could be responsible for loss compensation to the employee, payment of damages to the employee. It's a very broad, open-ended term, and you may have to reinstate the employee. What about the existing employer policies, the PTO policies? You know, as an employment lawyer, I recommend that the sick leave be pulled out of the PTO. I find it easier for the employer to do. Some of you aren't going to do that. You are free not to take that guidance in that regard. Your existing policy rule: an employer shall not be required to provide any additional sick leave if the employer has adopted a sick leave policy or time off policy that provides employees with an amount of leave which meets or exceeds the law. Now, there's a big caveat. However, most employers are stopping at that first slide. You still have to comply with the accrual rules. You still have to comply with the carryover rules, and you still have to comply with the use requirements. Now, if you do all those things, you're going to be in good shape. Now, what about the accrual rules? What if under the PTO plan, they only used part of their sick time that they had entitled? What do we have to carry over since it's all combined? We're hoping that the guidance that is eventually issued clarifies what these couple slides mean to you as an employer. Impact of collective bargaining agreement. Nothing in the law was going to be construed to prohibit an agreement. No, make sure you, if you're unionized, pay attention to this language. Entered into on or after the effective date of the section from providing a comparable benefit for employees covered by such agreement in the form of paid days off. Such paid days off may be in the form of leave, compensation, or other benefits or some combination thereof. You can't impede, infringe, or diminish the ability of the collective bargaining agent to negotiate terms and conditions of sick leave different from the provisions contained within the New York State sick leave law. The big thing is you're going to have to acknowledge in your CBA that this provision is meant to comply with the New York State paid sick leave law. Now, what about existing collective bargaining agreements? The law is silent, but you're going to have to reach out to the union, open up the discussion, because I do believe this is a term and condition of employment, and you're going to have to open up negotiations in that regard. Job restoration rule, just like FEMLA, paid family leave, there's a job restoration rule, but it's a little different. You must be restored after you take paid sick leave to your position. It's the same position in that regard. What if while you were out on sick leave, we went through your desk and we found out you were dealing drugs, you were watching pornography at work? Can I fire you? I think the answer is yes. It has nothing to do with the leave. It has everything to do with other conduct. You're going to have to make sure you document it, and you're going to have to make sure that you apply it consistently across the board in that regard. Employee usage rule. An employee can verbally or in writing make a request to the employer about, hey, how much sick leave have I used? An employer has to provide a summary of the amounts of sick leave accrued, a summary amount of sick leave used by the employee in the current calendar year or any previous calendar year. So the employee has this right. We don't know how long you have to respond. I wouldn't take too long to respond. Oh, I'm sorry. I totally forgot about this. You have to provide such information within 3 business days of the request. So make sure you, what I want you to do is have in place a procedure so the employee knows who to go to get this information. It's probably going to be payroll or HR. You don't want it going just to a general supervisor. They may poo-poo it and not respond in a timely manner. The impact of local laws you still have to follow if you're covered by New York City or Westchester County. You still have to follow that. Record retention requirements. The law amends an existing provision of the labor law and requires that you preserve for 6 years contemporaneous, true, and accurate records for each work week showing the amount of sick leave provided to the employee. I do have a record retention handout. If you email me, I will email it to you in Word form in case you want to create a written record retention policy. I'll warn you right now, it's about 60 pages long. There's a lot of written record retention requirements that are out there at this time. That is what we know of the law right now. The guidance can come anytime. I was hopeful it was going to be here before this presentation, but it's not. Once we do have the guidance, I'm going to update the presentation, put in the guidance, and then we'll do it again. We'll give you the full picture. I advise you all to wait for the guidance before and make an informed decision. Do you want to do the front load or accrual method? Then you have to take a step back, write your policy, distribute your policy, and then follow your policy to your employees. So I have about 15 questions I'm going to go through. There was one that was emailed to me yesterday, which I just want to discuss briefly. If for the employee count, what if I have one owner that owns 3 separate companies? They're not affiliates or subsidiaries of the other. They're 3 separate companies. Do I count them as one entity, or are they 3 separate? I would first take the position they're 3 separate, and what I have to give is dependent on that. There's something called joint employment, integrated employer rules. We'll see if the state adopts those or puts those in play, and we may have to reevaluate that. If it's one company and I have employees in New York, Pennsylvania, and Connecticut, do I count all of them? I think you do in that regard, but only your New York employees would be allowed to take the leave in that regard. I'm going to go now through the 15 or so questions that are in the chat box. Feel free to continue putting in questions in that one. So I'm going to go back to the beginning and just knock them off one at a time. I probably answered some of them. Oh, well, we'll just go through it again. If we already have a PTO policy, can we simply add the paid sick leave into this, or must it be completely separate from our company's PTO? You can combine, that is up to you. We recommend that you pull out to make sure you clearly prove compliance with the sick leave law. Next one, does the sick leave include benefit pay, or is it just hourly rate? It is the regular rate of the employee that is a term of art defined in wage and hour law. Can we pay out unused paid sick leave or not be required to carry over if done so? No, the carryover rule is there. There's nothing in the law that says you can get around the carryover by paying it out. Maybe there will be in the guidance, but as of right now, you can't do that. Does the net income rule fall off if it's over 4 employees? I answered that, yes, it does. Can we front load but control the number of days per month? I'm assuming what that means is, can we control the number of days of use per month? No, you cannot. This is now a protective leave, and if the employee wants to use all their paid sick leave in 1 month, they're going to be allowed to do so, and you have to restore them to their identical job. Another question, where does FEMLA come in? For instance, after 3 days, can we require FEMLA to run concurrent? I think so. We just have to remember this is paid leave, and some of the FEMLA rules make distinctions between paid and unpaid leave, and you have to make sure that you're doing it properly. Can we front load salary and accrue for part-time? Yeah, I think you can. I think you can have one policy for salaried and another for part-timers. I think you just have to put it in writing. There's nothing in the law that suggests to me you can't do that. But you have to properly put people in there. You can't mix and match. You have to follow your own rules in that regard. Okay. But we are not allowed to ask how it is being used. You can't require the disclosure of confidential information. My guess is the state is going to give us some guidance as to what we can and cannot ask. But that's really what I can tell you right now. We can't recoup a time of termination if we front load, even with an authorization signed by an employee. That is absolutely true. You would be in violation of the labor law. If an employee calls in sick, we can automatically deduct from this leave without permission. We assume it's okay to deduct, or do we need them to fill out something? No, I think you can deduct if they call in and the paid sick leave is clearly implicated. You can hit it. I would document it in some manner. I would wait for the guidance to see if they put any documentation requirements in it. As of right now, I think you can document it any way you wish. I I don't think it's required that an employee fill out some type of slip. You can make them if you want, and if they don't fill it out, I think you can fill it out for them. Will an employer be able to ask an employee for a doctor's notes stating they're physically able to return to work? I think it depends on exactly what is going on. Remember, we have the ADA and we have FEMLA requirements. But if Johnny was just out for a sniffle for a couple of days, I'm going to probably hesitate and say no is going to be the answer. But I think it depends on the reason. If they're out for COVID-19, I think the answer is going to be yes. I think the guidance is going to flush that out a little bit. What I gave you in the presentation is all the information that we have as of right now. Can we pay it out and not be required to carry over? I think I've answered that. The answer is no, unless they change that in the guidance. Okay, so for tipped employees, I have a question. It's a great question. I'm not sure I know the answer because it's not in the law. For a tipped employee who makes $7.85 per hour plus tips, when they use sick time, is it the New York State minimum wage for Central New York, which is $11.80? If we have to, depending on what the guidance says, you would pick, if the minimum wage is more, you pick the minimum wage of where you are. However, tipped employees, they're making $7.85 per hour plus tips. I don't know what they're going to do with the tipped employee. We'll have to wait for the guidance. We'd have to figure out what their regular rate was for the week, maybe. I don't know. I wish I could give you more information, but not yet. If we do not accrue, so you're going to front load and we have a new hire, does the new hire get 56 hours on their first day of employment? Yes. If the new hire is full-time and you have let's say you have 150 employees, you're going to give them that immediately in that regard. There's no probation. You could have a probationary period, but it's not going to make any difference whether they get it or not. You got to give it to them. Good question on the how much have you used? An employee makes a request. How much have I used and how much have I accrued? Can we just keep it on their pay stub? I think so, and I think that's going to be compliance. But remember, they have not only the right to ask for it for the current calendar year, but previous calendar year. So the pay stub may take care of the current calendar year. I don't know if it's going to take care of it. And you can just direct the employee to their pay stub. That's fine. What about employees who receive less than 200 on monthly stipend for minor job? They count as an employee. Yeah, they do. We're hoping they give some guidance, what I call per diem or these super part-timers. But yes, they're not going to get the full amount because they're not full-time. It's probably going to be some pro rata amount that they would, if you front load, and the accrual would just be based off of hours worked. Sometimes when they issue guidance, they don't answer all the questions, and we'd have to figure out what this employee's regular rate would be. Can we still hold them to attendance policies and discipline them for excessive call-ins? I don't think you can discipline an employee for use of paid sick leave. It is job protected. It is going to be considered FEMLA. Paid sick leave, it is job protected leave. You can't hold this against them in that regard. Okay, long question here, so just bear with me. Staff whom would accrue less than 56 hours a year due to working less than 30 hours a month are eligible to utilize the full 56 hours per year. I think it depends on what method you're doing. If you're using the accrual method, the answer is clearly no. They only get what they accrue based on your accrual policy. The state has set the minimum standard, 30 hours worked, 1 hour of sick leave in that regard. next part of the question. Also, do you have any link research that outlines the specific carryover for a large employer? No. I have taken what I've given you here right out of the statute. That's all that exists right now. I've slightly modified the language of the statute to make it easier for the presentation. But that's it. That is all that exists as of right now. I will tell you when the guidance comes out, we will do another webinar. I will also email the link to the guidance to the chamber so that they can distribute it to all of you in that regard. But that's all there is as of right now. The state will set up a web page in that regard. We're just waiting for it. Okay, so please explain the carryover again. You said the cap is 56 hours. If you front load 56 hours, how can any amount be carried over? Okay, let me start there. So in year one, you give the employee 56 hours. They don't use any. You carry over the 56. In year two, they have 56 times 2. They have what they carried over and what you front loaded on January 1. So now they have what, 112 hours. You can cap the use of paid sick leave. You can only use 56 hours a year. So what good is the carryover in some cases? In the front load, not a heck of a lot. If you cap it, but in the accrual method, there definitely is a benefit. If we are unionized and we made a bargaining agreement for a payout at the end of the year, would we still need to carry over? If it's a collective bargaining agreement that comes into play before or on or after the effective date, and you acknowledge this section, you have very broad authority to negotiate with the union in that regard, and that may be okay. All right, so next question. For employees that are flat rate or 100% commission, how do we determine their regular rate? It may not be feasible in some cases, and that's where the minimum wage may come into play. I would have to actually go into the regs of the FLSA to figure out how to figure out the regular rate for a commission-based employee. There is a rule on it. I just don't know it off the top of my head. If the employee has accrued 112 hours, 2 years of front loading, and then leaves on January 2nd, if we have a policy that says we do not pay a termination, we do not have to pay out. That is absolutely correct. Make sure if you don't want to pay out, you state it explicitly so the employee has no expectation of it. If you are a very generous employer, you are free to pay it out in full in that regard. Oh yes, thank you for this question, and we really don't know the answer. Multiple employer, someone that works for different contractors throughout the year. I haven't given it a lot of thought. To be honest with you, I'd have to think about it and look at the arrangement and the relationship. I can tell you this, Warren, the law is silent on it in that regard and doesn't give us any specific guidance. We're hopeful that the state gives us some more guidance in that regard. Okay, any other questions, please type them in. I've gotten through all of them. Mike, and I'll just do some concluding remarks in case there are no other questions. Wait for the guidance. Let's make an informed decision. Do we want to front load or use the accrual method? Write your policy, distribute it to your employees on before January 1. If you choose the accrual method, you just do it retroactive to September 30th. I don't think it's a big deal at all. Realize we have unanswered questions. We've gone through 20, 30 questions here. Some we know the answers to, some we do not. That's why we need to wait for the guidance. This is at least your first step into this arena in that regard. I have some questions. I've read a couple different articles from people, and depending on who the author is, the answer is a little different. So it's like, well, let's wait and see for the guidance to give you the whole picture. I have no other questions, Candace, so I'm going to turn it back to you. If anyone does have a follow-up question, not a year from now, but, in the next couple days or so, shoot me an email and I'll be happy to answer it. I will also send Candace at the Chamber the link to the guidance once it comes out, and I will promise to schedule another webinar to sort of fill in the blanks once we know the guidance. So thanks, and Candace, I'll turn it back to you.
Thanks, Mike. Thank you for the presentation. We will get this loaded to record and share with everyone afterwards. If there's anything else that we need to pass along, we will get that over to you as we receive it. But thank you everyone for joining us today, and I think we'll log off now.
I think we had a couple more questions come in right as Michael was speaking. So
sorry about that.
That's okay. They were literally, while he was speaking, they were typing.
Okay.
Okay, so can you hear me?
Yes, right. We can.
All right, so two other questions popped in. We need to know more about the carryover requirement. If we limit usage to 56 hours per year, then why carry over? The carryover is going to be helpful in accrual. So I accrue based on hours worked. I accrue 56 hours in year one. I don't use any. I roll it over. So on 1/1, I immediately have 56 hours available, but I continue to accrue. The rule comes into play. You just limit it for the hours worked per year to 56. You don't have to. You can let the employee use everything that they have accrued in that regard. So that's where I see it coming into play. And if you read a lot of the guidance that was published in New York City, that's what the intent is with the carryover requirement. You indicated we could treat salaried or other employees differently. Can you categorize by staff and laborers? I think so. As long as you're very clear in your policy which method you are using for which category of employees, and you properly categorize the employee, I see nothing in the law that says you can't do that. Now, there's a burden on you, depending on how big you are. You're going to have to track differently, and if you put information on the pay stubs, it could be different things along those lines. Another question that popped in, if we choose to use the accrual method and carry over without a cap, once this is written, can we ever change this to have a cap? Yeah, you are free to change the policy. What you're not free to do is to take away an employee's rights that the law gives them. So if you want to be generous and say, hey, no cap, you can use as much of your accrued sick time as you want. And then you're like, oh my God, what have we done? Can I change it? Yes, you can change it back in that regard. The only thing I always say is make sure there could be someone who's out on sick leave. I'd hold certain classes harmless, like a grandfather clause. Maybe just say, hey, if you're already out on sick leave, don't worry about that. We're not pulling it away from you. Or you do the effective date maybe on the first of a year or something like that. Another question that came in, if we front load and a new employee starts in December, then can take 7 days off with no questions asked. If we have a probation period, do we allow a new employee to take paid sick leave? Yeah, so let me answer the first part first. The probationary period and not being allowed to use sick leave, I don't think you're going to be able to do that. If you front load and the employee starts in the middle, like the end of the year, it sounds like the 7 days is some type of proration that you came up with. I think that's going to make sense to me. We have to wait for the guidance as to what you do with an employee who starts in the middle of the year and how you prorate it. I think it's a simple calculation to prorate it. It makes sense to me, but usually when that happens, the state of New York pulls the rug right out from underneath me and does something else. Wait for guidance on that in that regard. I love this question because I'm getting it a lot. Can you front load per month, i.e. 3 days per quarter? According to this statute, the answer is no. You have to front load all at once. You saw this, the slide I put in on the authority of the Department of Labor. The Department of Labor probably has some authority in that regard to modify, expand upon, and I think they may choose to do so, and we just have to wait and see. But my answer right now is no. Can we have an employee accrue for their first year and then as a 1-1 front load? I'm going to say no. I think you have to come up with classes of employees, and those classes have to make some sense. And you treat everyone within that class the same. And you may be doing that. I'd have to see as written. You are free to change from the accrual to front loading method. I think you have to make sure no one is hurt and you grandfather in people in that regard. You might be able to do some modified version of that. I'd have to see. I definitely wouldn't do anything, Joanne, until the guidance came out and we take a look at that. But you can change from year to year. There's probably going to be something in the law that says if you're doing that, you can't have a bad intent in that regard. The example that I would, and I don't know what it was, would be, I'd have to think about it a little bit. Some employers change their pay period every other week to mess with overtime, to screw the employee out of overtime. I don't think that's your intent, but they're probably going to put in place some provision that says you can't do it if you have evil intent or something like that. Next question. Our current policy states that illness beyond 2 days could lead to the request for physician documentation. Should that be removed? Can we ask for a return to work slip? Wait for the guidance. I think we're going to have to remove that if you are asking for confidential medical information. The return to work slip, I think, depends on the facts in that regard, because it could be, you could have a legitimate business reason. We want to make sure Johnny is capable of safely performing the essential functions of his job. I think they're going to give us some examples in the guidance as to what we can and cannot ask for. So we'll see. Stay tuned, Jessica. I'm very curious as to that as well. But clearly they haven't told us a lot. And that is all the questions that I currently see. I'll stay on just for another second, see if anything else pops up. Okay, going once, going twice, gone. All right.
Thanks so much, Michael. We appreciate it.
So, thanks everyone. More to follow, but again, hopefully you at least have a little better understanding of the path we are now on as we go into January 1. It's going to give you a lot to think about because there's a lot of business decisions you have to make here, and it may impact other policies as well. So the sooner you start thinking about it, the better, but do wait for the guidance.
All righty, thank you everyone. It looks like we aren't getting any more questions in, so I think with that we will log off here. Thank you all for joining us, and we will send the recording out to all of you soon.